Hello, greetings. This is Erick Widman from Passage Immigration Law. I'm one of the immigration attorneys over at our firm, and returning to you after I was interrupted by a couple of USCIS interviews last week. I'm returning with our weekly live Q&A where I get to answer immigration questions and provide helpful guidance, I hope, about our very frustrating and ever-changing immigration system. We have some good questions today, and we're going to jump right into them. Here's the first one. If I became a sponsor for someone who's crossing the US border, how would my naturalization be in the future? Can I pull my decision to be a sponsor at the last moment? So let's break the question down a little bit. And someone is wondering, who's not yet a citizen, what are their options in regards to sponsoring another person? And so the US government requires financial sponsorship in a few situations where a family member, for example, is applying for a green card, either through adjustment of status within the United States or outside the United States through consular processing. The US State Department requires that there be an affidavit of support, which is the financial sponsorship document. And there are some significant obligations connected with this affidavit of support, with this promise to repay the government if the person you're sponsoring, the person getting the green card, ever goes on food stamps, for example, or relies upon public benefits before they become a US citizen. So the US government can then go and ask you for reimbursement. Also in that Form 864, the person you're helping out could, it happens sometimes, so be careful, could actually sue you and compel support under that agreement. We thankfully over the years have not seen that often because people are trying to be helpful and nice rather than filing lawsuits against each other. But that's a risk the sponsor definitely has to watch out for. So this person's asking, could I pull my sponsorship at the last moment? So as long as you haven't signed the form and it hasn't been submitted, then you could in fact pull it or just not allow it to go forward. But after you sign the form and it's submitted, you're unable to withdraw that with the US government. You might also be referring to an affidavit of support that's Form I-134, which is used in some cases when primarily, for example, a fiance visa, or it's suggested it's an option for a visitor visa. But the person you're sponsoring, according to this fact pattern here, the person's crossing the border, and that involves consular processing, coming in on an immigrant visa. So again, be careful, make sure you understand the obligation carefully, thoughtfully in regards to your sponsorship of that person. But you also asked about, would it affect your naturalization? And yes, green card holders, by the way, can be sponsors. You don't have to be a US citizen. And you knew that, but I'm just confirming that for our audience. You're wondering, could this prevent you from becoming a US citizen? One of the requirements for naturalization is good moral character, that you're following through with your obligation, with your obligations. That's represented through taxes, but also with an affidavit of support. If you weren't following through with the affidavit of support obligations, yes, that could be deemed to hit you in the good moral character category. So yes, if you're not able to support that person and you're required to, that could be problematic. Okay, that was the first question. Next question. If someone's looking to hire our law firm to help you move from your current TN visa to a green card, how much will it cost me end to end, and what is the alternative process for going through the lottery system, but is very confusing. You don't understand. How much time in total is required for the process? And the current renewal of my TN visa took 10 months to get due to the backlog. So now I have just under 2 years remaining with the current TN visa. I need to find a new company that will be able to sponsor me as well. Thank you so much for responding to this question. Our pleasure. I'll do my best here to answer your question. And so as a TN visa holder, you're either a Canadian or Mexican. And that's a non-immigrant visa, and you're talking about sponsorship from an employer rather than a family member. So of course, for everybody, for your benefit, that is one of the main pathways to becoming a permanent resident. If a company sponsors an employee, and this person mentions that you're looking for a new company that would sponsor you. Apparently your existing company that you're working for on your TN is not going to sponsor you. So you looked into H-1B options, and there is a lottery with roughly a 30% chance of getting selected. So it's not a very reliable pathway to getting a visa, to getting this work visa. It's frustrating, especially because evidence has shown that many companies are gaming the system and filing multiple H-1Bs. There's a lot of evidence came out recently that happened a lot this past year. Okay, so as an alternative to the H-1B, you're thinking about, how do I get a green card through an EB-3 process, employment-based third preference category? How long will it take? What's the cost? And here's an overview. Here are the key categories and the steps for getting an employment-based third preference category green card. Okay, step number 1, you got to do a prevailing wage determination, file that with the US government, Department of Labor. That can take about 6 months on average, just for that prevailing wage analysis and determination to come back. Next, your employer has to engage in recruitment and show the US government they're recruiting for the position, they're advertising in a newspaper. That can take, at least as a minimum, and our business immigration attorney, David, confirmed this, take about 2 to 3 months as a minimum. And you have to show there's no qualified US candidate who's qualified, willing to do the work. Then there's a perm step. The perm filing, we have, and David confirmed, about 7 to 9 months for that stage. And then the employer has to file a petition, an I-140 petition. We're estimating 7 to 13 months for the petition, but that can be sped up a lot with an expensive but powerful option called premium processing. For $2,500, used to be $1,500, prior administration raised it to $2,500, but you speed that up to 15 days, 15 working days. That will move quickly, 15 calendar days rather. It'll go quickly. And the NVC process for visa applicants, it'll be consular processing for those of you outside the US. That can take 6 months to a year. The adjustment of status process within the United States can take a year or two with filing Form 485. It is not a easy, quick process, but a benefit for those in the United States who are doing an adjustment of status. Part of that, you're filing a work permit application, an EAD, an advanced parole application, and that will arrive in about 5 or 6 months. So even though the adjustment of status process can take a while, a year or two, you'll get work authorization in roughly 6 months. We at our firm charge around $10,000 to $12,000 in legal fees to handle this whole thing. We often tell employers, though, this is a lot of money, but it's less money than what people have to typically pay a headhunter from one of these recruiting agencies. So if they have a great foreign national, instead of having them look for a new person, hire you through this perm process, and everybody wins. So there's a quick overview. Let us know if you have questions. That's a pretty detailed question, and Our business immigration attorney, David, is even better equipped than I am to answer that. And just email us or call us, support@passage.law. Okay, next question. If I, a Dutch citizen, got married in the US with a US citizen, do I have the right to stay here in the US, or do I have to go back to the Netherlands or somewhere outside the US till I have permission from USCIS? Okay, well, congratulations on likely finding the right person to marry. Your fiance and you are probably discussing the options. Your fiance is a US citizen. And so one of the benefits of marrying a US citizen is that if you do overstay your current visa status, that is forgiven through the adjustment of status process. But you actually do have to get married, and you actually do have to file the adjustment of status paperwork. Sadly, this won't happen to you. I'm certain of it. But it's theoretically possible. We've seen it happen where couples break up after the foreign national overstays her visa, and then you're stuck with unlawful presence, and that's terrible. Your visa is invalidated, depending whether it's B1, B2 visa or the visa waiver program. So make sure you're really going to get married, you're really committed to one another, and you're going to file the adjustment of status paperwork. And then overstaying your visa is allowed. It is not something that's going to make you inadmissible to the US and keep you from getting a green card. So that's good. You don't have to leave the US. And by the way, if you did leave the US after filing the adjustment of status, you left without getting an advance parole issued, then the problem is that you would abandon your adjustment of status application. All that hard work would unfortunately unravel. So make sure you get this international travel permit called advance parole, and you will apply for that with your EAD work authorization card when you file your adjustment of status paperwork. So make sure you don't leave the US unless you have that advance parole. Make sure I answer the question. Do you have to go back until you have permission from USCIS? Well, remember, a second main option that many couples can take is if you can get married in the US and then complete the green card process from Europe. So that's also an option. You and your spouse can pursue an immigrant visa rather than pursuing a green card within the US. That immigrant visa requires you to be outside the US, go to a consulate in Amsterdam or The Hague, and then come into the US with your new immigrant visa, and then you'll immediately become a permanent resident upon arrival. Okay, last question here. Requirements. What are the requirements for a business trip visa for the purpose of meetings and negotiations? So you are allowed under a B1 visitor visa, business visitor visa, you're allowed to attend meetings, sign contracts, negotiate deals, and that's allowed under the B1 visa. Similarly, if you're from a visa waiver program country, the ESTA-based program, you're able to conduct business and come in for the allowed period of time, up to 90 days for the ESTA program. You're not allowed to work, but you are able to engage in these business-related activities. And that is a very common thing. A CBP officer at the border will understand, usually, that you can come in and do those business-related activities as long as you're not working. So it's good to have a clear idea that what you are going to be doing, and there is a list online with USCIS and with the State Department. The Foreign Affairs Manual also has a pretty exhaustive list of what's possible and what's not. So to get this visa, perhaps if you don't have one yet, you have to apply for B1. Oftentimes it's a double B1, B2 visitor visa at the consulate, fill out through the National Visa Center. You'll fill out a DS-160. You'll be invited to an interview at the consulate where you live. And then you have to establish to the satisfaction of the consular officer that you don't have immigrant intent. They presume this of everybody. It's built into the law that someone does have the intent to immigrate. So you have to show your ties and connections to your home country why you're not going to overstay your visa. So that's one of the requirements, in case that is something you're wondering about too. Okay, thank you for submitting these questions. The answers will live on in YouTube and elsewhere. We look forward to seeing you next week. Take care.